Now, without further ado, I'd like to ask Alex and Yvette to start their presentation. A quick introduction to both of them. Alex is a digital privacy specialist and a transactional advisor on the corporate and commercial team of Hill Dickinson. He has over 2 decades of experience in China and Southeast Asia. Alex focuses on data privacy, mergers and acquisitions, private investments, and franchise and licensing transaction. And Yvette, who's presented a couple of webinars, I believe, with us previously, so you probably might know her. She's a partner in the dispute resolution team in Hong Kong for Hill Dickinson. She's a litigator with extensive experience in advising and representing international clients on a broad range of disputes, including multi-jurisdictional corporate and commercial litigation, regulatory investigation and enforcement actions, media law issues, and judicial review. She also has experience in handling consumer protection and employment claims. So thank you very much, Alex and Yvette, for being our presenter for today and presenting on this very, very important topic. You can start sharing your screen and the stage is all yours. Thank you.
Hello, everybody. Thank you for attending our presentation today on the data privacy laws in China and Hong Kong. We've got a lot to cover, so we're going to try and do it quickly. I'm going to dispense with the introduction of the firm because I think many of you have heard of us. If you haven't, we're not a massive firm. We're a medium-sized firm. We've got about 1,000 people spread out over 8 offices between Asia and Europe. So without any more introductions of that nature, I'm going to get right into it. Now, of course, you're all familiar with the GDPR, or I hope you are. I mean, it is made a lot of headlines in 2018 when it was passed, and it's a very comprehensive extraterritorial regulation. It applies everywhere, and the fines are very, very big. And now, of course, we have China's equivalent, which is the Personal Information Privacy Law. It's going to be effective in about a week and a half. It's got extraterritorial application, very big fines, and an element of data localization. So there's a lot to go through in this presentation. I'm going to try to get through as much as I can. It's a large body of law, and I don't think this is enough time, but I'll do my best if you bear with me. Of course, there's the Hong Kong Data Privacy Ordinance, which my colleague Yvette will talk about after I complete this presentation. So anyway, I hope you enjoy this and learn something. And if you don't, then challenge me with questions. So what I want to address first and foremost, which is relevant, you may or may not know this, but I think it's important to address because the Personal Information Privacy Law, like the GDPR, is principles-based. And it's important to understand the distinction because traditionally the kind of laws most people think of are prescriptive in nature. They're very detailed. They tell you what you can and what you cannot do. And as long as you comply with the letter of the law, you're okay. You haven't broken the law. In this particular case, with the principles-based law, it's very much about the spirit of the law. They're drafted broadly, and it imposes high levels, high standards, and there's an expectation that you are going to be accountable and that you are going to use your best judgment to comply with the spirit of the law and not just the letter. So there are prescriptive elements. So right here, as you see on the screen, are 7 principles that are the guiding principles that underlie most data privacy regulations these days, okay? So you have the principles of lawfulness and fairness and transparency. And so what that basically means, if it's lawful, you've got a legal basis to process the data, okay? Then it takes you to the purpose limitation, okay? You can't process data from every subject under the sun. You have to specify the purpose and achieve that purpose and be clear what that purpose is. Whereas data minimization, for example, kind of precludes you from collecting all the data under the sun as well. The idea is that you collect the least amount of data necessary in order to achieve your purpose in processing data. Accuracy, well, it's important to have accurate data. And why? Well, because if you're processing the data of a data subject and the result of the processing could end up with some kind of legally binding effect or legal consequence, if you have inaccurate data, then you could end up with the incorrect result, which could penalize somebody. Think credit ratings, for example. Now, there's a storage limitation, and that storage limitation isn't about how big your hard drives are, I promise you. It's about determining how long you're going to keep the data and not keeping it for longer than you need to keep it to achieve your objective. And of course, it's the principle of integrity and confidentiality, which, as you can imagine, relate to security, okay, both from external and internal threats. Accountability, in gray at the bottom, is one of the most important things because this entire body of law, whether it's the PIPL or the GDPR, are about accountability and ultimately about exercising your judgment to ensure that you are doing the right thing. Now, these principles are important enough that I've actually created tabs and put these principles on the bottom of each slide. So it gives you some context and as a reminder what it is that we're talking about. And you'll notice on one of the slides, somewhere in my presentation, one of the principles is incorrect. And the first person who can find it and just indicate that you found it and what it is that's wrong in the Q&A section or the chat field, the first person I'll take out to lunch. Let's see if you're paying attention. Okay, I really want to talk very briefly about a general approach to data privacy. It's not addressing specifically the PIPL, but it's relevant to the PIPL and the GDPR, and generally any principles-based data privacy approach. And I want to do this briefly so we can get into the substance. But the first thing, it's got to be top-down. You need to have buy-in from the top. It is the most important thing, because without that, you will never have a culture of privacy, and you'll end up with infractions, whether you like it or not. The next step is to assess. It's a starting point. Everyone needs a starting point. And I would say that one of the starting points that's very important is your data inventory map. This is a map that tells you what data you have. Not exactly, not the specific data, but the categories of data. So for example, you have someone's first name, last name, physical address, email address, a mobile phone number. You might have their copy of their passport or their ID or ID number, for example. And together with that in your inventory map, for example, you want to know what's the legal basis for the processing? What's the purpose of the processing? What's the method? Where is this data? That's very important. For the PIPL, is the data stored natively on the company servers? Is it outsourced process where you're using a cloud? Is the cloud in China or is it outside of China? Because of course now you're transferring data outside of China if it is. You need to know who has access to your data, for example. This is another part of your assessment. This is in your company, who's got access? Have you black boxed it essentially? Have you limited access of data to people who need that data for a particular function as opposed to giving people access to everything? Because that creates a threat or a risk. You might deal with third-party vendors or third parties outside who need to have access to your systems, your infrastructure in order to supply you with services or goods. So that's a potential risk as well. Now, I want to discuss very briefly the idea of a privacy policy versus a privacy notice, because people seem to confuse the two. The privacy policy is internal. This is about how you handle data within your company, who has access, who handles it, how they're supposed to handle data. The privacy notice is external. The privacy notice is the thing that data subjects see if they're going to subscribe to your social media platform, or they're going to buy products from you on your e-commerce platform, for example. And this privacy notice is going to have a bunch of details which they need to have for you to be compliant with the personal information privacy law. And I will address that specific topic later in the presentation. All of this should hopefully yield standard operating procedures that are really usable within your company that you can deploy so that you know at the different levels of the company, people are doing the right thing. So let's move on with this. Okay. One of the big issues with the personal information privacy law is territorial scope. And the GDPR addresses this as well, and it also addressed in Article 3 of both regulations. Now, of course, the personal information privacy law, or the PIPL, applies to everybody in China, but it might apply to you if you're outside China, if you're providing goods or services to people within China, or you're monitoring the behavior of people within China from outside China. Now, the government, the CAC, has reserved the right to expand this scope, as I point out in this one little bubble on the side. But if you are one of those people, if you're outside China and you're selling goods or services to people inside China, or you're monitoring the behavior of people, and people meaning natural-born person, not legal entities, okay? Then you need to either establish a dedicated office in China or appoint a designated representative, okay? And this could entail some liability, but of course you need somebody there with whom the authorities can communicate. And as a means of you being able to communicate with authorities there as well, like the CAC, the Cyberspace Administration of China. And once you've done this, you're going to need to inform the CAC of who this DPO, data privacy officer, is, or the address of the designated entity or the representative. And just to address one key issue, of course, Hong Kong is part of China, okay, but it is still one country, two systems, and we do have a different legal system here. So, well, we have our own data privacy laws in Hong Kong. Because of this, the personal information privacy law will most definitely still apply to you here in Hong Kong if you are selling goods or services to people in the mainland from Hong Kong or monitoring the behavior of people in the mainland from Hong Kong. I'd like to move on to Article 4 of the PIPL, which basically defines and addresses what personal information is. It's quite similar to the GDPR. Personal information is basically any information that relates to an identified or identifiable person. It can be recorded electronically or in writing, but the fact of the matter is identified specifically or identifiable. That means if you've got a certain number of data points that don't specifically identify a person, but you can tease out who that person is with the information, they're identifiable, and therefore it's personal information. On the other hand, anonymized information, which is not covered by the PIPL, can't be used to identify any specific person, okay? It's been taken apart. It's been completely de-identified. It's been anonymized, and it's been synthesized for that matter, because there's synthetic data now as well. But basically, you can't restore it. You can't reverse engineer it, okay? There are no personal identifiers. Now, there is the element of sensitive personal information, similar to the GDPR, and this is the kind of data that if disclosed to the wrong people or public, it could really damage a person, damage their dignity, their reputation. It could actually harm them, or it could harm property or the security of a person or property. And some examples of the kind of personal or sensitive personal information that we're talking about are biometric data. So you think fingerprints or retinal scans or your face for facial recognition, religious beliefs and specific identity, the actual identity of a person, medical information, financial information, location data, particularly like metadata, for example, or any personal information of a minor under the age of 14. However, unlike the GDPR, racial and ethnic origin, political opinions, trade union membership, sexual orientation are not considered sensitive PI under the PIPL. Now, there's also an issue of nomenclature, because the words that are used in the GDPR are different from the PIPL. I only raised the comparison because we've already had 3 years to get used to the GDPR. So under the GDPR, there's this concept of a data controller. The data controller is the one who collects and decides what to do with the data, the purposes and the means of the processing, if you will. Whereas a data processor takes instructions. A data processor is somebody who's told what to do, and they must adhere to those instructions. And the distinction matters because there are different levels of liability for a controller versus a processor. Under the PIPL, a data controller is a personal information processor, but essentially it's the same. They determine the means and the purposes of the processing, and a commission party or entrusted party is the person or the company that is going to take instructions. Their only job is to provide the hardware and the security. Other than that, they do everything. And one other point, just to clarify, if you're not sure what processing of data means, the loose but accurate description is any action performed on data. Sending an email is processing, just for example. Now, this is a particularly important topic, okay? And it addresses the legal basis for processing. Now, typically in the past in China, people were heavily reliant upon consent-based legal basis. But now, with the personal information privacy law, it's expanded the realm or the universe of potential legal bases for processing data. And it's a bit similar to the GDPR. For example, the performance of a contract. Well, if you have to process data in order to perform a contract that somebody enters into with you or that you enter with them, then you have a reason to process their data. Perhaps you have to perform a legal obligation. It could be related to employment, paying people salaries, or, for example, providing insurance or social welfare, MPF, for example. There are also exceptions or a useful legal basis in the case of a public health emergency. If you think of COVID, for example, data might need to be processed or shared for the benefit of the public good. This is a vital interest issue. You want to prevent the spread of a pandemic, for example. There's also news reporting and media monitoring in the public interest. Now, the law specifies that's within reason, But we don't know more yet. And since the law is not effective yet, and there are no implementing rules or policy guidance yet, we're going to have to wait and see on this and a number of other issues, of course, as well. Of course, you can also process personal information that's already in the public domain because it's been disclosed by the data subject. Perhaps the data subject is a profligate poster on social media and they don't use their privacy settings, for example. So they're putting their information out in the public domain. So that also could be a legal basis. Now, going back to consent, because consent, of course, is still a legal basis, but it's codified now. It's clear that consent has to be informed. The data subject has to know what they are consenting to. It has to be freely given, okay? So there can't be coercive tactics used to extract the consent. It has to be clearly demonstrated. In other words, it can't be tacit, and it can't be, you're in until you opt out. This is more of they have a right to opt in. So this is data privacy by default. And it has to be freely revocable. But there is no legitimate interest basis under the PIPL as there is under the GDPR. And I would also like to address that we do see under the PIPL, which we haven't seen elsewhere, is this concept of separate consent. And so that separate consent is necessary, for example, if personal information is shared with an additional personal information processor and it wasn't already something of which the data subject was notified in the first place when there was an original consent or some other basis for the processing. Or let's say the disclosures that a personal information processor makes exceed the scope of the original consent, then you would need to get a new separate consent. If, for example, a processor changes the purpose or the method of processing data, it would require a separate consent. And then, of course, in the case of processing sensitive personal information, you most definitely need a separate consent. And there must be a very specific purpose. You have to demonstrate that there's a sufficient necessity in order to process or for processing this personal information that's sensitive. And there's going to be a much different threshold in terms of the security that you have to provide to protect that data. And then, of course, any transfers of personal information outside of China are subject to a separate consent as well. And the legal basis is important. I should add this, and I have this little red note here. The legal basis you choose, there's no best legal basis, but the legal basis is important because it's going to affect how your company responds to the data subject rights requests, okay? Because there are different conditions and exceptions, and limitations with respect to those requests. And if you choose the wrong legal basis and therefore you don't deal with data subject rights requests properly, then you end up in a situation where you could be found liable or be sued by the data subject, okay? Or you could be found to be processing data illegally. So choosing the right legal basis is quite important. Okay, before I told you about privacy notice elements in the beginning and the generality about what goes into the basics of a privacy program, and I told you to discuss privacy notice elements, and these are they here. So a privacy notice has to be accurate, conspicuous, clear, and you have to do this, give this to a data subject before the processing begins. And it's really important that it's clear because right now, Facebook, for example, is having some problems with allegations about their privacy notices being so convoluted and so complicated that people have to jump through different pages and cross-references to understand what they are. So that's not an example of something that's necessarily clear, okay, for a data subject. But at the very least, you need to offer the name and contact information of the processor or the data privacy officer or the designated representative, for example. You have to articulate the purposes and methods of processing so people understand what data you're collecting, why you're collecting it, how are you going to process it. And you need to also talk about the categories of personal information you're collecting. So what is it that you need and how long you're going to keep it. And you also need to clearly express how data subjects can exercise their rights. And I'm going to talk about data subject rights in a little while anyway, so we'll jump into that. But I should note that if any one of these elements changes, okay, you're going to have to notify every data subject. Now, there are different ways of doing that, but anything changes, you have to explain it. And this will take us now into data subjects' rights. Now, data subjects have the right to know. And what does the right to know mean? Everything I just discussed in the prior slide about the privacy notice. Who's the data privacy officer or the processor? Why are you processing their data? What's the process? What's the retention period, et cetera, et cetera. They have the right to erasure. Now, that right to erasure is not absolute And I can give you an example of when it's not. But generally speaking, a data subject can require deletion if, for example, the purpose of the processing has already been achieved. For example, performance of a contract, you performed all your obligations, it's done, it's over. You have no reason to keep the data anymore. Or stopping the provision of a product or service, or the consent is revoked, or the purpose of the processing is impossible to achieve, or the retention period expires. You can read the slide. The point is, there is an example of when you might need to keep the data. Let's say, for example, somebody has consented, a data set has consented to a company contacting them for marketing purposes, for example, and the company has the phone number or the email address, for example. Well, in that particular case, if you were to delete their data, then actually you'd be doing them a disservice. You need to have a segregated data set for these requests so you can keep this data on file simply so you can actually comply with that request not to contact them anymore. Otherwise, if you delete the data, you have no record of them, they might be contacted again. Well, that's one example. There's also a right to access and portability. Access meaning they want to know what data you have on them. It could be anybody with that data, or they might want to move the data. Portability meaning that they want to migrate their data from one platform to another. We don't know any details on this yet. And again, we need to wait for implementing rules or some kind of policy guidelines. I'm sure the CAC is going to weigh in, as I put in over here. People also have the right to rectification. And rectification relates to the principle of accuracy. People want their data to be accurate, and they have a right to ensure that it is accurate, especially when legally binding decisions of automated decision-making might occur with the data. And again, people have the right to withdraw consent easily. Again, the exercise of these rights have to be easy. They have to be convenient. It has to be clear, okay? And a personal information processor can't reject a data subject's exercising of their rights without a good reason, okay? If there's no valid reason, then they have the right to sue you, and that's expressed in the law itself. The response to data subject rights requests have to be timely. Now, I don't know what timely means, but let's assume within a reasonable period of time until there's more elaboration on what these ambiguous terms mean. And unlike the GDPR and any other data privacy laws that I've seen or deal with normally, decedents, dead people, typically have rights. Well, I should say their close surviving relatives have rights under the PIPL. They have the right to access the data, to have the data corrected or deleted. So that is a bit of a departure from other data privacy regimes. Now, I'm going to talk briefly about personal information processor obligations, okay? You have to have a program that ensures that data is handled compliantly. Compliantly means in accordance with the applicable law, but also in accordance with these principles. If you adhere to these principles, there's a very good chance you're going to be compliant with the personal information privacy law. It has certain idiosyncrasies, which we can discuss later, but let's just assume that you're not going to be handling core data, important data, or state secrets. And if that's the case, then I would say if you adhere to the principles and you know the law, you'll be in a relatively safe place. But I don't want to be cavalier, and I don't want you to be either. Now, this is a risk-based approach. It really depends upon a company's operating model, okay? Are you an e-commerce platform? Are you a social media platform? Are you a bank that does KYC? It really depends. But these are cornerstones, okay? You need to have a good internal management system. So that will address your standard operating procedures. How is data handled and why? And you need to have a good privacy policy internally that guides your data privacy culture, okay? You need to have good data mapping so you can classify data and inventory it for all the reasons we've already discussed. You need to know what you have in order to assess the risk in storing it and processing it. And if you know what you have, then you can adopt adequate security measures because you need to know the level of risk involved. And this will determine whether you encrypt data or whether you store de-identified data, how you transfer that type of data. And then, of course, you need to have operating and handling limits. And this will address things, for example, like aging, like the retention schedules, when you keep data for how long and when you delete or get rid of the data. And this is also going to encompass things like education and training. You need to educate your staff, not once, not twice, but regularly. as things change, as conditions change, as risk assessments determine the conditions have changed. And you're also going to have to train third parties to have access to your data sets, for example, as the case of vendors or any of the third parties that need to access data that you store. So these are essential PIP obligations. Okay, now, I didn't actually, talking about this, I didn't hit the last one. And this is an incident response plan, okay? And I apologize for that. The incident response plan is just that. What happens if there's a data breach or there is the incorrect disclosure of data, right? And this is really, really important because you need to know what to do. And usually it happens at the most inconvenient time, and you don't want to get caught with, well, you don't want to get caught in the corner, like you just said, okay? Now, in this particular slide about data breach notification, I think it's better to call it data incident notification because the PIPL responds specifically to the concept of data incident, and it's quite broad. Okay, and a data incident could be a loss of data. I mean, well, how does a loss of data happen? Well, it's not just you lost it, but you can notice that somebody accessed and took data. You maybe have corrupted drives. Something happened where the data is corrupted. Who knows? Well, you have unauthorized disclosure. Well, that could be because of the willful act of somebody within the company who chooses to improperly disclose data. It could be simply putting the wrong email address in an email and sending sensitive data to the wrong recipient. It could also be intentional tampering of data where the data is changed, okay? And then there's a likelihood wildcard. Now, this doesn't appear anywhere else. It doesn't appear in the GDPR, but it appears in the PIPL. Okay, and I'll get to it in the section on triggers, right? Because why do you need or when do you need to do a data breach or incident notification? Well, when an incident occurs or when an incident is likely to occur. Now, I'm not sure what that means, and I've talked with a number of people, and they don't really know what it means, but I'm sure the CAC is going to elaborate and is going to tell us a bit more over time. I can imagine, for example, if for some reason some security system fails, that there might be a higher likelihood that a breach will occur or an incident will occur, and maybe that's reportable. But again, it is a wild card simply because now you have to report what you know and report maybe what you don't know. Okay, it's a bit complicated. So when do you have to make a notification? Promptly. And in this case, I would interpret promptly to mean immediately. Okay, as quickly as you can. And who are you going to notify? Well, you're going to notify the Data Privacy Authority. Now, the primary data privacy authority is the Cyberspace Administration of China. And then you also have to notify affected data subjects, okay? Unless the processor's taken measures to basically stop or prevent the harm, okay? In which case, there's no point unnecessarily scaring the data subject when there's no risk. However, a data privacy authority could override that, okay? I also want to point out that there are a lot of overlaps between the cybersecurity law and the data security law and the PIPL. And because of that, there might be multiple stakeholders in the data privacy enforcement arena or the cybersecurity enforcement arena in China. And it could be the National Security Commission or the Ministry of Information and Technology or the Ministry of Public Security or more locally the PSB or the China Securities Regulatory Commission or the Banking and Insurance Regulatory Commission, because they all have bits and pieces of data privacy requirements as well. And at the very least, the content that you're going to put in the notification will be the kind of categories of personal information that was affected. And of course, if you've got a good data inventory map, then that shouldn't be a problem. You need to know the causes of the incident, or at least address the causes of the incident. What kind of remedial measures are you taking in order to fix the problem or solve it? And if you haven't been able to solve it yet, what will you do? And what are you doing in the meantime? If you do need to actually contact affected data subjects, then you have to articulate effective mitigation measures for the data subjects. What can they do to protect themselves? For example, somebody accessed their passwords. Well, you need to contact them and tell them they could change their password ASAP, right? And of course, there needs to be the contact information of the personal information processor or the data privacy officer so that the authorities know who to contact. Now, this is a topic that, of course, a lot of people want to talk about, which is cross-border data transfers. Because of all the talk about data localization in China, this seems to have been a hot topic. Now, this is obviously going to require waiting time to understand how the rules are implemented more fully by the CAC. But at the very least, we know right now that a PIP has to inform data subjects that they're going to transfer data overseas. And we already know before that even might involve a separate consent, right, as we addressed earlier. But the data subject has to know who's receiving the data, what's the recipient's name, what's the contact information, why are you sending it, how are they going to process it further, what data are they getting. They need to know this, and they need to know whether they have a chance to do this. I got to speed along here. I'm being told that my time is running short. Also, if you're going to send data overseas, you're going to have to adopt some kind of alternative safeguards. Now, the ones you've all heard of before are statutory, are the standard contractual clauses, okay, such as what we see in Europe. They haven't developed these yet, but I'm sure the CAC is going to issue them as soon as they can. You might have to pass a security assessment, especially if you're a critical information infrastructure operator or a large processor. We don't know what large means yet, but we'll learn, I'm sure, soon. And you're going to have to do some kind of transfer impact assessment, just to address the kinds of risks that are involved in transferring the data overseas. Now, an important issue here you need to remember is you cannot transfer any data out of China to foreign law enforcement or courts without an approval. And how that's going to work, we're not sure yet. I'm going to talk briefly about the EPAAs. I'm not going to go into too much detail because of time issues, but I can tell you, unlike the GDPR, which is not clear about when you do DPIA, just simply when there's a high likelihood of risk to the rights of the data subjects, at least the personal information privacy law does specify the triggers as to when you need to do it. And that's helpful. That will guide us so that we know at the very least with these basic things, we must do it. Of course, you still have this concept of accountability. So you're still going to have to use judgment to decide when you might need to do a data privacy impact assessment, even if it's not in one of these enumerated pieces here that are under the law. Okay, ultimately, the impact assessment exists to be able to assess risk. Are you handling data? Is the processing legal? Is it legitimate? Is it necessary? And what protective measures do you need to take? As far as recourse is concerned, people have the right to complain. There is liability for damages and strict liability. There doesn't need to be proof, okay, that a personal information processor did something wrong. If there's damage to a data subject, it's going to be presumed. It's a res ipsa loquitur, if you're familiar with that term. And penalties and fines. I'm sure you've heard the headlines. Basically, there are two categories, right, of infractions, ordinary and serious. We don't know what the distinction is yet. We will learn, I'm sure, in due course. But you can remember the fact that for serious cases, the fines are between 50 million or 5% of your annual revenue. Whether or not that's global or just in China, we don't know. But you should note that there is personal liability, okay, for managers and people responsible for data privacy. And that can manifest itself in terms of fines or bad social credit scores. So it's something to be avoided. Okay, I'm nearing the end here. I just want to talk very briefly about these additional rules. The cybersecurity law deals with networks and network protection. Okay, if you've got more than one computer and those computers are communicating with each other, you've got a network, and technically you're a network operator. The data security law applies to all data. The personal information privacy law just applies to personal information. Cybersecurity law covers all data as well. Now, if you have any other questions, you can ask me. I'm available by email. Happy to respond to you. I would like to point out a little self-promotion. I've worked very hard to get my IAPP certifications, and I was amazed. I was looking through the IAPP directory recently, and I found in Hong Kong, there are only 3 people that have both CIPP and CIPM qualifications, and I'm one of them. I couldn't imagine it. And in Greater China, I'm one of 10. Now, okay, it's a bit self-aggrandizing, but I was very surprised when I found that. I thought there were more of us. Nonetheless, I would say you'd be in good hands talking to me or anybody else who's got these certifications. They'll be quite knowledgeable and be very, very well able to steer you in the right direction and answer questions. Anyway, thank you very, very much for listening to me. I hope I was clear. I hope I wasn't confusing. And again, I'm open for questions at any time. Thank you.
Hi, everyone. I am now about to talk about the data privacy law in Hong Kong and the new changes made to it since 2 weeks ago. So I was just saying that, as most of you know, the main legislation in Hong Kong governing personal data privacy is the Personal Data Privacy Ordinance, the PDPO. It aims to protect privacy of individuals about their personal data and is applicable to both private and public sectors. The Privacy Commissioner for Personal Data and his office, which is short PCPD, is the regulator enforcing the law in Hong Kong. And here's the role so far. The law was passed in 1995 and then came into force in 1996. Major amendments were made in 2012. At the time, the focus was on direct marketing. And then in January 2020, the Constitutional and Mainland Affairs Bureau issued a discussion paper which sets out proposed amendments to the PDPO. 6 major amendments were contemplated. Number 1, mandatory data breach notification. Number 2, additional regulation of the data retention periods under the law. Number 3, more sanctioning powers given to the Privacy Commissioner. And then number 5, widening of the definition of personal data. And number 6 is the regulation of doxing. So out of these 6 proposed amendments, only the anti-doxing provisions have come into force on 8th of October, just shy of 2 weeks ago. Just a quick refresher on some key concepts under the PDPO. Here are the key definitions. Personal data is defined as information that can identify a living individual. Data subject, self-explanatory, person subject to the personal data. Data user is the person who has control over use of the personal data. And then data processor is a person who processes data on behalf of the data user, not for own purposes. It is to note that the data processor is not directly regulated under the PDPO at the moment. So if I am an employee, I will be the data subject of my personal data, for example, ID records, health records, and contact information. My employer will be the data user who collects, holds, uses my personal data for employment purposes. If my employer outsources some part of its function to an external party, for example, an agency, to carry out pre-employment screening and checks, that agency would be the data processor. Here are the 6 data protection principles under the PTPO, what we also call DPPs. I will not go into over detail in here, just to set them out on the screen. And now we go to the new amendments. As mentioned, only the anti-doxing provisions have come into force on 8th of October. So what is doxing? The term itself actually does not appear in the legislation. This is how the Privacy Commissioner describes it. In general, doxing refers to the gathering of personal data of target persons or related persons, such as family members, relatives, or friends, through online search engines, social platform and discussion forums, public registers, anonymous reports, etc., and disclosure of the personal data on the internet, social media, or other open platforms, such as public places. This is straight from the website of the PCPD. So gathering and disclosure of personal data in public domain. So curiously, it does not mention the key ingredient of no consent, which is in all of the relevant provisions in PDPO. Before amendment, disclosure without consent focuses on the data user's consent. After the amendment, as you can see on the screen, the content is shifted to that of the data subject. And as you can see, there are certain qualifiers. Intention to harm is an element of a new offense. The amendments introduces 2 new offenses. One, the less serious one, is a summary offense. As you can see on the screen, it's subject to a maximum penalty of 100,000 fine and imprisonment for 2 years. This is the text from the ordinance. So a person commits an offense if the person discloses any personal data of a data subject without the relevant consent of the data subject. And the introduction of the intention element is here in subsections A and B. You can see that a family member is also included in this section. And in subsection B, being reckless as to whether any specified harm would be or would likely be caused to the data subject or any family member of the data subject. 2 points to note here. Number 1, recklessness suffices as intention. And number 2, how does one measure the likeliness of whether any harm would be caused? How likely is likely in quotation marks? This is not defined in the ordinance. The more serious offense is an indictable offense subject to a maximum penalty of $1 million fine and 5 years imprisonment. You can see here the subsection A is the same as the summary offense we've just seen. The additional element is subsection B. The disclosure itself results in actual specified harm to the data subject or their family member. So specified harm under the ordinance means harassment, molestation, pestering, threat, or intimidation to the person, bodily harm or psychological harm to the person, harm causing the person reasonably to be concerned for the person's safety or well-being, or damage to the property of the person. So I've tried to summarize these concepts in the previous slide under the post-amendment box. And now we come to the new powers that the Privacy Commissioner has when enforcing these new provisions. Before the amendment, when the Commissioner receives a complaint or has reasonable grounds to believe that there's a contravention of the PIPL, the Commissioner may conduct an investigation. The Commissioner may also publish a report setting out the results of the investigation and its recommendation if it is in the public interest to do so. If it is found after investigation that there's a contravention of the PIPL, the Commissioner may issue an enforcement notice to the data user directing remedial and preventive steps to be taken. Non-compliance of the enforcement notice issued by the Commissioner is an offense with maximum penalty of $50,000 fine and 2 years imprisonment. And then the Commissioner also has inspection powers to check for compliance with PIPL. Contravention of the DPP itself is not an offense, but the Commissioner may serve an enforcement notice after investigation, and non-compliance with the enforcement notice is an offense. You may also be familiar with many codes of practice and guidance notes issued by the Privacy Commissioner. They are not legally binding, but like all of these guidances issued by regulators, any breach of their recommended best practices will give rise to a presumption against you in any prosecution or legal proceedings. It's important to note that before the amendment, the Commissioner has no prosecution powers and must refer all cases to the police and the Department of Justice. So this slide sets out all the new enforcement powers of the Privacy Commissioner since 8th of October. So they may now request for information, require answers to questionings, and ask people to make statements. They have arrest powers, search and seizure powers, which are very presumably include Dawn Ray type of powers, which are vested with other regulators. And they can also do so without warrant in urgent circumstances. But the first question that jumped out to me was, being a disputes lawyer by training, is there a right to silence? The wording of the new amendment suggests no. And one of the new provisions under the PIPL actually offers some protection against self-incrimination for compliance with the request. But, and that's a big but, there are limitations. It is very important to consider these provisions when responding to the Commissioner's request pursuant to its new powers. I should mention that these new powers are only applicable to investigation of the new Section 64 offenses that we have just seen, or failure to comply with or obstruct the Commissioner's request or provide false and misleading information. Also, the Commissioner now can issue cessation notices requiring the cessation or restriction of disclosure of doxing content. Under the law, the cessation notice must identify the doxing content, specify the cessation actions to be taken, and the deadline to do so. It has extraterritorial reach in the sense that whether the disclosure was made in Hong Kong or not, the cessation notice can require a cease and desist. And also it may be served on a person in Hong Kong or an overseas service providers. Failure to comply with the cessation notice is an offense. There is an appeal mechanism, and the appeal must be brought within 14 days. An important note here is that you will still have to comply with a cessation notice even if you're lodging an appeal, as the appeal process does not suspend the operation of the cessation notice. But the Commissioner can also apply for injunctions for large-scale or repeated offenses. I believe this is targeted at a class of persons when not all persons within that class are readily identified individually. Otherwise, issuing a cessation notice would appear to be much easier and quicker for the commissioner. And there is a built-in immunity in the ordinance itself. If you comply with the cessation notice, there can be no civil liability incurred to you. I've included here some recent decisions, but they are not under the new amendments as they have just come into effect. They are similar offenses prior to the new amendments. So you can see how the courts have approached them and the penalties involved. These are included for your reading pleasure if you're interested. Sorry, just before we go to Q&A, some concluding remarks. The new amendments were pushed through the legislative process very rapidly and possibly in record time. The business and legal communities have raised various concerns over the amendments, and many of them still lack clarity. For example, the privilege against self-incrimination that I mentioned earlier, not everything that you hand over can be protected by this statutory protection. Also, there are statutory defenses under the new offenses, where the phrases lawful excuse and reasonable excuse were used. We do not know how they are defined. Possibly they mean different things. Otherwise, the same term would be used consistently. But it's not explained in the PDPO. And we hope that the Privacy Commissioner will issue some guidance on this. And lastly, my key message to legal counsel, it is important to educate the business and your colleagues all the way up to senior management, as presumably these cessation notices will be issued to those in charge who can or have the say to take action to comply with the notice. Importantly, tell them not to ignore any cessation notice or correspondence from the Privacy Commissioner. So we all know CEOs, directors, or managers are very busy people, and by the time the cessation notice reaches the legal's desk, it might be a few days might already have been passed. The notice would likely carry very tight time frame to take rectification steps. Bearing in mind, non-compliance is an offense, so it counts right after the expiry of the deadline. And there are only 14 days for you to consider challenge it by appeal and put together the actual appeal. I would say it's an all hands on deck situation. You will have to identify the offending material, where it is held, how many copies are there, who can remove it, how do we remove it, are you actually able to comply? If not, you will have to notify the Privacy Commissioner immediately. And if yes, you will have to comply, but important points to consider are, will you preserve rights under your compliance? And you say you comply under protest if an appeal is contemplated, which is a 14-day deadline. So my advice is contact your lawyers, contact us right away. And now, if we have time left, we have a few minutes left, and Alex is back joining us.
Great. Thank you. Thank you so much, Alex and Yvette. We see a couple of questions coming in. Are you able to see them, or do you want me to read them out to you?
I can see them.
Okay.
All right. Is the appointment of a DPO mandatory requirement in China? It's not a mandatory requirement, as far as I can see. It depends on your size. Okay. The PIPL uses words like companies handling or processes handling large amounts of data or major amounts of data or huge amounts of data. And it's a bit ambiguous, but I can say for sure, if you're a tiny company or a small company, probably not. Or if you're a very big company, then probably, and you probably need it anyway. That's my answer. I hope it's not much of an answer. I'm sorry, but I hope that helps a little bit.
Yes, so we've got another question on anti-doxxing. The question was, what does disclosure mean? Does it include reposting someone else's social media post? I would say yes, because disclosure means that making it available in the public domain, and by reposting someone else's post is also a publication to the public domain. I hope that answers the question.
No, someone's asked, if you're a foreign company but have a mainland Chinese customers, is it mandatory to set up a rep office or agency in China? Well, under the extraterritoriality provisions of Article 3, if you are selling or providing goods or services to people in China or monitoring their behavior, then you should either have set up an office in China or hired a designated representative in China. And that's a bit similar to the GDPR, right? So I'm sure that a whole industry will pop up of people that are for hire or entities for hire that might act as designated representatives for this particular purpose.
Hi, I've just received another question on anti-doxing. Are there any exemptions for the media? There are exceptions under the PDPO itself. Media reporting is one of them. As to how that would be integrated into the new provisions, it remains to be seen. I've just received another question. To the best of our knowledge, is there any recent case prosecuted pending prosecution based on new doxing law? Alex, have you seen anything?
No.
I don't think so, but maybe it's not in the public domain yet.
Right. Thank you very much. You can keep sending questions. If Alex and Yvette don't have time right now to answer to them, they will get in touch with you and try to answer your questions. We have a couple of more minutes, actually. And I've got some questions over here. I'd like to ask you these questions. Can we keep data if we think we'll need it again in the future?
Not really. I mean, think about it this way. If you think about the principles, right, there's the idea of the data minimization principle and as well as the data storage principle, right? The idea is you collect the least amount of data that you need for the purpose, and you don't keep it for longer than you need to achieve that purpose, right? So if you happen to collect data for one purpose and you're using a legal basis for that purpose, let's say consent, just for argument's sake, and you got consent for that purpose, if you use it for another purpose, you're going to save it for a rainy day in your little account, then you'll fall afoul of the law.
Brilliant. Thank you very much. And just before you go, very important, we've got about, I believe, almost 270 attendees right now. And for their benefit, when should a company conduct a data privacy impact assessment?
Well, to be quite honest, before you do any processing of data, I mean, that's according to the principles and the rules, right? You don't always know what you're going to find. I mean, if you think about it this way, a data privacy impact assessment, it's a bit like a business plan. Now, most people won't start a business without a business plan. It's your roadmap. It's like going on a road trip, right? You look at the map and you highlight your route. But a data privacy impact assessment is going to help you do that. You're figuring out, okay, what data are we going to collect? And why are we going to collect it? And what are we going to do with it? And then you need to know, well, maybe this data ends up being sensitive data. Or if you have enough data that it makes the person identifiable and you have different security measures. So the data privacy impact assessment can tell you a lot about your operations. And in fact, I'd go so far as to say it's not static. It's an ongoing thing. So that basically, if you even change one aspect of the data processing protocols related to, let's say, what you did a data privacy impact assessment for, if you change something in that processing, you're probably going to have to revisit that data privacy impact assessment and do a new one, as you change things. So yeah, it's really important to do, and it makes a lot of sense to do. Always, you have to do it.
Great, thank you. And Yvette, maybe you can see there's one last question that's come in. Can you answer it in 30 seconds?
Well, I might talk about this briefly. As far as the cross-border transfer of personal data, I mean, Article 33 of the Data Privacy Ordinance addresses that, but it hasn't been ratified yet. So to my knowledge, there's no restriction on the export of data from Hong Kong, as far as I know.
Great, brilliant. Thank you so much, Alex and Yvette. That's our time for today.
Well, I got a quick question. I mean, did anyone ever find the incorrect data privacy principle, which I included in the slides?
Well, if you have found it, you can send us a chat message, and Alex will be very happy to take you out for a lunch.
Okay.
Okay, we'll wait to hear from the person who found it. Thank you so much again, Alex and Yvette, and their details are on your screen at the moment. If you'd like to get in touch with them, if you have any further questions for them, or if you like a copy of their slides, please do get in touch with them directly. Thank you very much. And I'll ask you to now close your webcam and make sure that your microphone is on mute.